Good morning, everybody. I too want to ditto what Braulio just said about Judges Greene and Gillespie and Powell for putting this together, as well as Braulio and all of his folks. The only reason I wanted to join in and let everybody know what's going on here is just a couple minutes, so I don't have to continually repeat things. The courthouse is a vast array of different divisions and different issues, and every day seems like something comes up we haven't thought of the day before. As far as operation, we are trying to operate as much remotely behind the scenes as we can. We're working on a virtual reality courtroom with a Zoom platform in all the divisions. All the judges are aware we're trying to hold as many hearings as we can. We changed the administrative order to indicate that parties cannot now just agree to cancel a hearing. They need the judge's permission because there was a lot of games being played with that apparently. So we changed the administrative order. It's really the judge's call as to whether to let the parties cancel a particular hearing or not. As far as time, RAO runs through April 17th. We're going to amend that probably next week to go through the end of the month. If we don't change it to the end of the month, we may well change it to the middle of May. I can't really see under even the best case scenarios that courthouse is going to be operating normally. At the very earliest, mid-May. After that, it would probably be the end of May. Then you have, of course, the holiday, which is somewhere towards the end of May also, that plays into this. Probate isn't as much affected by jurors and whether jurors will come back in timely after we reopen the courthouse. Even when we reopen, I think there's going to be a certain amount of trepidation in large groups. So we still have a lot of things to work our way through here. We're trying to do as much as we can so we don't get too far behind when we reopen up. But that's kind of what's been going on. It just appears from what I'm seeing on the chief judge's calls and the governor's statements in the media that mid-May probably is the most optimistic of reopening times. And so everybody's just going to have to be patient. I understand there's a lot of pain out there with law firms, but there's also a lot of pain with people not being able to sell hot dogs and other things at the Marlins games, who are far less off than we are. So I just want to give everybody an update on what's going on and where we are, and we'll certainly let you all know through administrative orders. And Braulio, if you guys have any questions that you all field for me that Judge Greene and the others can't answer, forward them on to me in an email, and I'll be happy to answer them.
10-4, will do, Judge. Thank you.
All right, thanks everyone. Have a good day.
Thank you. Are we able to get Judge Gillespie?
Hi, Judge Tudor.
Are we able to get Judge Gillespie or no?
Hear you, Judge, but you can't see me, so.
Okay, well, all right. I've been nominated by the division as the administrative judge to initially speak to everyone. So first of all, I want to thank Braulio, the Broward County Bar, for putting this together. We have a sellout crowd of 500 people, which was the limit on the license that the Broward County Bar had. There are many others who attempted to get on. I understand that this will be taped and they'll be able to see it at a later time. On behalf of Judges Powell, Gillespie, our General Magistrates, General Magistrate Laventura and General Magistrate Nanny, we all thank you for what you're doing during these incredibly difficult, unprecedented, and trying times. We are extremely sensitive to the needs of counsel to operate their firms. We're extremely sensitive to the parties' desire to move forward as best as possible during this crisis. As anyone who practices in this division knows, probate guardianship is extremely paper intensive. Currently, the clerk of court is only providing essential services. That's pursuant to the order of the Supreme Court as well as our administrative order. In our division, there are 4 items or 4 things that constitute essential services. They are Baker Acts, Marchman Acts, emergency temporary guardianships, and petitions for vulnerable adults. The remainder, the clerk's office does not have any obligation, nor with their skeleton staff are they really able to adequately address or to service. As the judges, we are trying to service the community and the bar. We are here to work. We have been working since this all started, and we continue to do so, even though we all work under very difficult circumstances. Each of us and our judicial assistants and our staff attorneys are working remotely. We can communicate with each other through either cell phone or email. The judicial assistants can only communicate with you, members of the bar public, through email. I just implore on you, please do not nitpick on them. Do not think that we can operate as we normally do under normal times. We simply cannot. Now, that being said, there is no one in the courthouse. So neither mail, FedEx, nor courier, well, courier can't even walk in the door, but none of those are being received. We ask you as much as possible, please try not to submit non-essential work. And you have to search your conscience on what is non-essential as opposed to what it is that we can do. Just to explain to you, if we have a file and we're in court under normal circumstances, we, each of the three judges and the magistrates, we each review our work prior to the hearings, the day before, the morning of, days before, whatever it might be. And when we receive a file and we have an order, literally it may take us a few minutes to review because we have the papers, we have the pleadings, and we can look in CMS if necessary, which is our equivalent of the clerk system of Odyssey, which we don't have. And we can enter an order. And it may be that each order takes 3 or 5 minutes, depending on its complexity, some even a little less. Under the system that we have, literally, this is taking 10, 15, 20 minutes for each and every order between reviewing it, trying to find the necessary documents, if they exist in our CMS system, cutting and pasting, putting it in CMS, entering it through. Understand, we really have no support from the clerk's office. Now, our orders are entered through our CMS system. They exist in our system, but they may not be validated. You as practitioners may not have the ability to get certified copies. Now, in anticipation of the shutdown, the three of us worked very hard refining methods and preparing orders that would govern hearings. Braulio, if you can show the first order, please, the ex parte order. Someone put it on, start it again is what I got. Okay, so at the risk of boring everyone, so Braulio, this is going to be the first slide if we get there. If not, I can read it. I don't really, whatever's easiest at this point. The essence of all.
It seems to me that the problem started when we started using the slides. So I'm throwing that out there just
now it seems to be
because
working.
that's when the problem started.
Yeah, may have been coincidence because now the
Perfect.
slides seem to. Okay, as I said, and I don't know where we left off, so I'm just going to start again. Remember, we're not getting any mail. We're not getting any FedExes. Please try as much as possible not to submit non-essential work. Remember, we're getting very little, if any, support from the clerk's office. Even though we're entering orders on CMS, they may not be validated. You, as practitioners, may not have the ability to get certified copies. In anticipation of the shutdown, the three of us got together and we worked very hard to try to enter orders, anticipating that we'd be shut down to the public, but not even realizing that we'd even be shut down to ourselves. So things have changed. But on the ex parte orders, we need these orders, proposed orders, to be submitted in a Word format And please also include whatever the supporting documentation is with the case number. Understand that the clerk's office is not preparing the paperwork that they normally do for ex parte. They're not furnishing the docket to us. There's no way electronically that we can know, other than your email to our JAs, that you are requesting a ex parte order. Keep in mind, it's not a docket, it would be an order. Now, motion calendar is many times very, very similar to ex parte, except, and we'll go to the motion calendar slide if we can, except that the clerk's office made a decision a long time before I ever joined probate guardianship that certain things could not be heard ex parte, had to be heard on motion calendar. So again, what we're trying to do is we're trying to enter orders without hearings, if at all possible, and obviously unless the matter is contested. And if it's contested, try to work together to see if you can come up with an agreed order. If you can put it in our portal under agreed orders. Either way, if we're going to have a hearing, and Braulio, can you get that second slide or no? On the motion calendar one? If we're going to have a hearing or whatever else it might be, again, we need that petition. We need the order. We're not going to take any evidence. We're not going to take any testimony during motion calendar. And you can request your motion calendar hearing as you normally do in CMS so we can keep a calendar going. If we have a hearing, we need to have an access number. We need to have a PIN number in the notice of hearing. Otherwise, there's going to be no way to reach you. We still on? We good? Or we lose it again? I think we're on. Okay, let's go to special sets. Special sets are going to require a same procedure with a couple of differences. They're going to require, again, an access number and a PIN number. We will be calling in. All petitions, all motions have to be e-filed with a copy supplied showing the e-file reference number. If we're going to take testimony, we need a redacted identification of the person who's going to testify filed. What do we mean by redacted? No official information. We're looking for a picture and we're looking for their name. We're not looking for any other confidential information that may be used by someone if they had their hands on it for some purpose other than what we're intending to be used for. We're only going to receive testimony and we're only going to receive evidence if it's stipulated to. Now, if there's evidence, you can stipulate to it, you can file it, and you can show the exhibit numbers. Alternatively, if you can't do it and you're going to contest issues such as authenticity, admissibility, whatever it might be, you're going to need some sort of custodian who's also going to have to be as a part of the hearing. And that could be a special master, it could be a court reporter, it could be anyone who you come up with who will have a copy of the marked exhibits. And at the end of this crisis, they will file those with the clerk of court. Keep in mind, again, no testimony, no evidence is going to be received absent a filed stipulation and additionally saying that you're willing to receive testimony or evidence, and also that we have the documents. Again, orders can be submitted into the CMS portal. The necessary documents can be uploaded. Now understand that since we've had this shutdown, many of these documents, petitions that you filed earlier, and certainly that you filed since, may not be on the clerk's docket. And the way the CMS docket gets populated or our information is from the clerk's docket. It gets transmitted over. So if it's not on the clerk's docket, it's not on our docket, hence we can't see it unless we're provided with it. We're going to go to number 4 now, Braulio, which is going to show everyone a link. And I'll read it to you if you want to write it down so you don't have to look. It's http://www.17th.flcourts.org/agreed-and-proposed-orders // That is going to show you how you can now get onto the proposed order portal, which is different from the agreed order portal. Number 6, please. Volume. Now, in order to make this work, that's what it's going to look like. That's your tutorial that you're going to be able to see. So that will help you. And now we'll go to the next one, which is going to accentuate what we need. It's not just the order. It is, if you can get that right page, Braulio, it is the need that supporting documents have to be uploaded to the portal with the proposed order. If we don't have the supporting documents, please understand we probably cannot enter the order simply because we have no access to the supporting requirements or information we need in order to do so. Now, the manner of hearing, and I think we've kind of proved it all today. The three of us have unanimously showed and discussed among ourselves that our preferred method to conduct hearings is telephonic. This has been working well for each of us. We've each handled complex hearings. I've had hearings with 10, 12 attorneys by telephone. It works. So what we need is, in the notice of hearing, is we need the access number and we need the passcode. We ask, and everyone's been really great about this, please be prepared. That's the first thing. Second thing is, when you are not talking, please mute your phone. Third, please be patient. We may be on another hearing, and this is really even more so in motion calendar. You're all noticing it at whatever time our motion calendar starts, and we may have to make 10 or 15 calls. So please just be patient. We promise you, if we have that notice of hearing, we have a access number, we have a passcode, we will call you. Again, no testimony, no evidence can be received absent a filed stipulation and the needed documents. The orders, as I've showed you now, and as you'll see, can be loaded into CMS. Necessary documents uploaded. Again, please understand that many of the documents are not going to be there because we simply don't have them. Now, the other method, and I know Judge Tudor talked about this, is Zoom, or a method such as we're using today. We found that it's pretty cumbersome to try to use this absent a legitimate reason. Now, if you have a legitimate reason, we ask you to set a quick telephonic communication or hearing as to why. It's cumbersome to work. I tried one the other day. It took more than an hour to get it going. You see the problems we've had today, and technology is overwhelmed. The telephone systems seem to be working. Now, if you want to have a court reporter present for the hearing, that's fine. Give the court reporter the access number. What we also ask is that whoever has ordered the court reporter, please do a pleading, e-filing the name of the court reporter, the office of the court reporter, telephone number, and the hearing date, so that at a later time, keep in mind, if we were doing this normally, our clerks would be collecting court reporters' information and putting in the docket. This way, it will be present in the docket. It's imperative that you also state who the person is that's speaking. Keep in mind, the court reporter is not seeing you. And even for us, without a court reporter, there are times we may not know who it is. So instead of having to ask who's speaking, just be good enough and say so. Now, keep in mind that orders entered on CMS may not be validated. They may not be available as certified copies. We do have another page, Braulio number 7, which is from the clerk's office on how to obtain certified copies. I'm going to presume, no, that's not it. There it is. I'm going to presume that you're all familiar with this. If you're not, try to make yourself familiar. Again, we cannot guarantee that the clerk's office is going to have this available. We're doing the best that we can. We are entering the orders into CMS. We are completing our judicial work, and we can do no more. So hopefully the clerk's office may be able to get you certified copies. If not, maybe you can take the electronic copies where you need to. and get some help, some satisfaction during these difficult times. Now, you can take that down, Braulio. We are trying to be incredibly flexible. Let me give you some examples of some issues that we have. You may have a petition for administration to open an estate. Ken, you're here now. Welcome.
Thank you, Judge. I've been here. You just couldn't see
Oh, no,
me.
but we can see you. That's what's great. So anyway, you may have a testate petition for administration, and you may have e-filed the will, but we don't know whether or not anyone's in possession of an original will. We are relying on the integrity of the attorney of counsel who has filed the petition indicating that there's a testate will, that they will send the original to the clerk of the court by mail, FedEx, or when this crisis is over, they're going to get it in. We're relying on your integrity that you have that original will in your possession. Death certificates, e-file the death certificate, send the original to the clerk. We're going to proceed on petitions as long as we've received a copy of the documents with the e-file number. That's really important. Don't send us a separate piece of paper saying, or to our JA saying that we filed these. We need to see the document and the e-file reference number will be on top of it. On petitions for sale of property, where you need in that order, and we've gone through this time and time again, where you need the order to say that it's being sold at fair market value, you need to attach certifications, appraisals, Broward County Property Appraiser's website, whatever it might do, or whatever is needed so that we can make that finding. On guardianships where you're selling property, we need something additional. We always need the value. It doesn't matter whether you're seeking an order of fair market value or not. We need the value to protect the ward, and we need a statement signed by the guardian as to why it's in the best interest of the ward that the property be sold. Now, we're going to ask a favor again. Our JAs are working incredibly hard, as are all of us. Please try to minimize your emails as much as you possibly can. There's so many people who practice in this area. We're trying to help each and every one, but there's only so many of us. Our JAs are overwhelmed. We're working as hard as we can. Phone calls, 99.9% are going to be unanswered. So that's where we are during these incredibly difficult times. And that being said, I have two colleagues who I know want to address you as well, and I'm going to turn it over to them. Who's going first?
I'll defer to you, Mily.
All right. Thank you. Thank you. I too am very grateful to be able to have this opportunity to have the Broward Bar put this webinar together so that the bar knows what's going on, because the three of us have had to change the way that we do business. And I want to go back to what Judge Tudor said initially. And I think just the fact that the courthouse is closed, and basically what we heard today is it may be closed to the end of April, it may be closed to mid-May. Things are changing for us every day. We planned for a shutdown, and there were things that we thought were going to occur, and all of a sudden they stopped occurring. We stopped getting what we thought we were going to get from the clerk's office, and we had to regroup and move things around so that we could accomplish what you all needed accomplished, and really what we're required to do. The JAs, I know Judge Greene said this, but the JAs are receiving just a staggering amount of emails. Those emails are being forwarded to us. I want to point out something that's obvious to everyone, but as things are sent, sometimes people forget. When ex parties were scheduled, they weren't scheduled for the same day that you filed them. Sometimes you'd have to wait a week, sometimes you'd have to wait a couple of weeks, sometimes you'd have to wait 3 weeks to get on the ex parte schedule. What is happening now is that people are sending an ex parte request, and they think it's going to be done that day, which it's not. Just about 100% of the time, because not only are we keeping up with our hearings, and I have an average of 12 to 16 hearings a day, we also get all of the paperwork from the clerk's office as to the mental health cases. We're doing the Marchment paperwork, we're doing the Baker Act paperwork, we're doing we're doing everything that the clerk's office would send us. That is still coming. Unfortunately, the internet system is not as fast as what we had in the courthouse, and something that would take us 3 minutes to look at is taking us 7, is taking us 9, and that's when we're lucky to be able to get into CMS, be able to open the document, and be able to read it. So when Judge Greene said, please attach things to what you're sending us, please upload your documents. When you do that and we open it, we can see everything. There's no jumping around to any other system. There's no delay. It makes things a lot simpler for us to be able to accomplish. I want to just make a note with regards to Zoom. If there is an occasion, and I think by now we've all worked with JIS. I know, well, we've all worked with JIS on Zoom. If something needs to be accomplished through Zoom, you are going to have to agree that Zoom is the official record. If you don't have a court reporter there and it's being recorded, there has to be a stipulation filed, at least in my cases, that you agree that Zoom will be the official record for purposes of the hearing. And the last thing I want to say is I've had several situations where people send in things and put them on CMS, and then at the same time send them to Marlene. If you do that, I'm doing the work twice, and I'm not doing other work that I could be doing for you or for somebody else. So please only send your documents once, because if there's something missing, we're going to let you know. If everything is fine, you're going to get it signed. But when work is doubled up for us under this system, where it's so difficult to jump from one thing to the next, it's really very, very difficult to get as much accomplished as we want to. Okay, I think I've touched the points that I want to touch. I want to tell everybody that the phone system has worked fabulously, and all of you that have had hearings with me, and many of those hearings have required more than one party to be on the phone. I've had hearings where I've had 6, 7 attorneys on the phone, and it works. But please be by your phone. Remember that we're calling each of you one by one. So things that used to take me 20 minutes to do, sometimes it takes me, it doesn't take me 20 minutes to get somebody on the phone. But if I was able to do my cases in 20 minutes and it now takes me 50 minutes, then know that it's just the fashion with which we're having to work our hearings. So with that, Judge Gillespie.
Good afternoon to all of you, to the 500 participants or so. I want to limit my comments so we can take questions. But before I begin, let me say this. Behind the scenes with Judge Greene and Judge Powell, we have been committed to making sure that we run the probate division as smoothly as possible. I don't know if all of you had an opportunity to look at the administrative order from our chief judge from the Florida Supreme Court, Kenneth, where he talks about what is essential services. We are extending our services beyond the Chief Justice order, limiting to what has been defined as essential services to those cases involving mental health, emergency temporary guardianship, Baker Act proceedings. We are conducting business as usual. We've talked with Chief Judge Tudor. He has given us the directive to try to run our division as smoothly as possible, and we are going to do that. I like to use a lot of analogies, and I'll use this analogy to allay the 500 participant concerns is that we're going to have a lot of turbulences through this process. And what that means, we're going to be the air traffic controllers here. We're going to direct you around it. Judge Greene, Judge Powell, we're committed to making sure we get your order signed. It's very important because you folks have a business to run. So this is one of these crises that we have not, that no one could have predicted this crisis, but you guys are impacted by this as well. And it's 3 judges, and we're going to try to run Broward County, Palm Beach, and Miami to the best that we can. So we're going to open it up to question, but before I do so, let me tell you some takeaways that I think we should, that we should all focus on to make all of our jobs a lot easier. As you know, Judge Greene mentioned there will be no setting of ex parte proceedings, but that doesn't mean that we can still conduct hearings in an ex parte fashion. As we know, we do 2 forms of reviews. One you would ordinarily set in front of us and get your order signed immediately. And then the other will be an ex parte review through our staff attorneys. Our staff attorneys are up, they're running. Our JAs are remotely, they're running. So with respect to setting your hearings ex parte, continue to do what you're doing. We're utilizing our special motion practice dockets to somehow to overlap those with those ex parte hearings on those things you may need on an emergency basis. So please utilize them. With respect to the non-emergency hearings that you want to just set, but you would do so in the normal course, continue to set them. But I will say pace yourselves on that. We get a lot of emails, hundreds of emails, and sometimes your petitions, your motions, and those orders get lost in the process. So what I would ask that, to the extent that you do have cases on our special shadow motion practice, that you send us an order in email format, in Word format, and like 5 days prior to that, much like you would be doing if you were setting an ex parte, and that will allow us to look at them in advance, and we'll know kind of have some degree of I guess, or some order to how we receive the orders. Judge Greene mentioned earlier, we have been working with our tech at the courthouse to allow you access to the portal system through this case management system. It's very important that we focus on that for just a moment. That system was only open for agreed orders. There is Braulio has listed a basic tutorial, so to speak, how you can process those orders to us on a case-by-case basis. Now, if you upload your order, upload your petition, your motions in order to that CMS system, we have the ability to look at those, to look at your petitions and to approve them on the spot. That's very important because we couldn't do that before, but only to those matters that were agreed. Now we're opening it up to allow you to do that. Now, what that does is that once you become proficient at how to upload your petitions, your motions, and orders, it gives us a chance to review them as we see them, and we can go and approve those orders. Now, I will say this. If you do that and you also set them on our special set or motion calendar, and you see that we signed those documents, could you please go back into the system and cancel your hearing on that? That will eliminate our reviewing those files and then learning that we've already signed them. So we put that in place for all of you to exercise that portal. And it gives us a chance to move through those documents a lot quicker. So that's basically my comments on that. And again, we're going to try to navigate you guys around around what I consider to be cumulus clouds, so to speak. And we just got to reroute your way of doing, our way of doing this. It has been working. I can tell you that on the cases that we've been conducting telephonically, we're getting through them. And you probably have received calls from me. I'm sure you received calls from Judge Greene and Powell that we're probably beyond beyond looking at the documents. I'm already looking at Wednesdays and Thursdays, so we're calling you on things we can sign perfunctory. We're doing that to free up our times to deal with the contested hearings. So, so from the Gillespie division, I'll tell you, and I'm sure Judge Powell and Judge Greene agrees, let's just keep doing what we're doing, and we'll keep moving it forward. And you learned for the first time, the participants that I learned today, that that we're probably going to be in the May. Did I hear Chief Judge say that correctly?
Did.
I did in May. So you guys are learning as we
Yes.
learn. That was the first time we've heard of it in May. I thought we were up until April 17th, the last administrative order. But so it's looking like we may be at this for at least a month or so. And so we are committed and making sure we run the probate division as smoothly as possible. So with that, I guess the participants have some very important questions that they want to pose to the judges. So Braulio.
Just let me chime in a couple of little cookies. One, and I know Judge Gillespie didn't mean this, we are willing to service the Miami Palm Beach lawyers, any lawyer that has a case in Broward County. We're not working for their documents. Okay. The other thing is, and
I mean, through the entire state of Florida, but I'm saying most of it we did with the Tri-County lawyers, but it's open to everyone.
we're trying to enter orders, and whether it's special set or motion calendar, without the necessity of a hearing. So if you get an order back, please help us. And you've already requested that hearing on CMS. Please cancel the hearing.
Right.
Or if you can't cancel it because you're outside the time limit where you can cancel, just send a quick note to our JAs saying that you've gotten what you need and therefore it can be canceled. We'll cancel it. It'll help us tremendously. We may be getting choppy again. I don't know. The other thing is we are doing letters and orders of administration. So you should all know that. And we're doing that ex parte for the most part.
Judge, can I comment on that, Judge? I'm glad you mentioned that on letters and orders appointing PRs, meeting will, and those type of things. We are taking the position that as long as the death certificate has out and the will has been, one order, and she did follow my there. You don't to the courthouse, and if you're trying to overnight this, risk with all that being lost. I just don't know. Really, if I were a lawyer, I'd probably hold on until the courthouse opens. So what we, as a division, you have a will and or death certificate, if you have those documents, will open
Judge Gillespie,
position. That's okay. We will sign your letter.
you are cutting in and out, and this is a really important thing you're talking about.
It is okay. Repeat myself on that. Okay, I'll on the letters and admitting will mention that if you possession an original your possession, friends, and I Judge Greene and Powell, I would like those in your possession. If you want to take the risk overnighting them, I have found that some do that, they're lost. So we've taken a position, if you certify that you have the original death certificate and the original will in your possession, you hold on to those until the courthouse opens. We're fine with that. Then you can file them and you get your receipts. With the certificate, what it does for us, and let's say, because all of us tend to forget, if the certificate is in there at the time of discharge, we can at least look back and say the attorney certified, we do need the original death certificate, we do need the original will, and we won't discharge unless we have those in the event that you forget. But it would be my preference on my cases that rather than overnighting them, that's one expense, hold those, and you can always file them later as long as the certificate is there indicating they're in your possession. So and we're able to move forward on our openings. So that's my thought process on that.
Excellent, thank you.
Okay.
We're getting
Okay,
a
you're
lot
very
of-
welcome. And one other thing. We I spent some time at the clerk's office last early in the week at our administrative judge directive, and putting up a link how to obtain certified copies online. And some of you may say, Judge, well, it really doesn't work. Well, that's the best we can do. I had one case dealing with a bank that was giving us some problems. I made a phone call. I can't do it on all cases. Made a phone call. That's what we have here. We're doing the best we can, and it was ultimately accepted. So on those things that require certified copies, let's take a stab at it and try to obtain a copy, and let's see how that works. But we did have a case earlier last week that we were able to work things out, and it was eventually accepted.
Thank you. We're getting a lot
so
of
we're open to the
questions regarding orders. So I just want to clarify, for ex parte hearings, the proposed orders should be emailed to the JAs in Word format. But for motion calendar and special set, they should be uploaded to the system?
You can.
Yes.
Go ahead.
Go ahead, Judge. No, you first, sir.
No,
No.
we're trying to be able to do it with the portal. So even on ex parte, if you can put them in the portal, that's fine. Keep in mind, we're not running an ex parte docket. All we are trying to do is accomplish the need. The need is that you get the order that you're seeking. So for those, again, just put them in the portal. We're looking at that portal. We're starting early in the morning, and I can tell you that, speaking for the three of us, there are many times at 7, 8, 9 o'clock at night, we're still on this thing. And some of you have probably seen orders that have been entered in the portal from me at 12, 1 o'clock in the morning, and I'm sure from others. So we're looking.
When you say portal, you mean the e-filing portal, not CMS?
Okay.
CMS, forget, you have to go through the e-filing portal in the first place, because when you upload your documents into CMS, we have to see that reference number printed on the document. So it's 2 steps for you. You do your e-filing as you normally would. You then print out your e-filed copy and you upload that into CMS with your proposed order.
Does Powell, because I have a comment.
I may have misunderstood the question. I may have misunderstood the question, but I thought the question was, when you have a motion that is on the calendar, should the order be updated to the CMS portal? Was that the question?
Well, I think everybody is looking for clarification on the different types of hearings between ex parte, motion calendar, and special set, as compared to the COVID-19 order that was issued that specified to email the JAs with the Word versions of orders.
Okay.
So are there different procedures for ex parte
All right.
and motion calendar, or is it all the same?
This is a work in progress. When we
Okay.
put those 3 orders in, 1 second, when we put those 3 orders out, we anticipated, one, we'd be having access to the courthouse. We anticipated a lot of things that didn't happen. So we worked hard with our information systems person to be able to open the portal. That only just recently happened. And
Okay.
now that it happened, you should try to take advantage of the portal, Because if you're e-filing them to our JAs are then emailing them to us. We then have to open them in the Word version. We have to copy them. We have to then go into CMS. We have to paste them. We have to do a whole bunch of more steps. If we can get them in the portal, it's going to work a lot better.
Okay, so e-file is normal, upload to CMS.
Okay.
No
I-
emailing.
All right,
Yeah.
I want to clarify something. If it's on the motion calendar, I want the order sent to my JA because I'm having a hearing on that, and then I will be entering the order, and sometimes those orders, I add to them, I change them. So I don't want the orders on matters that are set for motion calendar to be uploaded because that's going to make it a lot more difficult. If you have if you have an ex parte motion, then you can upload that order to the CMS portal and attach the ex parte motion or petition. Because that I look at, it's right there, it's not set for hearing. And then, of course, if you've agreed to an order, those orders should continue to be put on the agreed orders portal. But at least on my cases, please do not put on the CMS portal the orders that pertain to the motion because I need them attached to the motion. So when I read, when I see what is on the calendar, I can follow through. And if the order's fine, I'll upload it and send it out. But I have to be able to differentiate, and it's going to get very confusing if everything is uploaded, but part of it is on the motion calendar, and I'm having to look through 50, 75 orders. So that's
This is also a point of
that's my
clarification.
thought.
Point of clarification, I think, to simplify matters. Judge Greene alluded to it earlier. When you file your documents, as you all know, there's a difference between you're filing it, a document, and getting something from the clerk's office indicating that you have filed it, and it's something different saying that they have accepted it. They are behind because they're running a skeleton crew as well. So what we've decided to do is that if you file a document and you have a reference number and you want to e-file something to our JAs, make sure we get the e-file and reference number connected with that motion or petition and your orders in Word. Now, the distinction that Judge Powell and Judge Greene are making is this. On the ex parte proceedings, where we're not looking at contested hearings, you can set those in our CMS and also the documents there as well, because what that allows us to do, remember, when you email our judicial assistants, depending on how many emails they get, we don't get them spontaneously. So there could be a delay. But if they're in our portal, you got your documents there, the supporting documents, and your uploaded orders, and it's something that we can sign perfunctory, we would do that. Now, to distinguish what Judge Powell is saying on the special set hearings, I agree in part that on those type of hearings, you are to email the orders in Word form to our secretaries, but there may be, after those hearings, there may be where if we have changes to those documents, I may then direct those to be put in CMS. So let me tell you why why we're saying we want them in Word. If we get them in any other format, when we try to put them, upload them into CMS, there's an encryption that they're off, and a lot of time you see these orders that come out and nothing looks aligned. That's why, and we're finding that in Word, at least everything looks judicial, so to speak. So that's why we're asking. But I will invite the parties to please take advantage of CMS and attach your documents there. As Judge Greene pointed out, out from time to time. If we have time to look at them, they're perfunctory orders, you get them immediately. Now, I think, Samantha, if that's you, I think that if I anticipate the next question is this: once you sign the orders in CMS, how are they being validated and things of that nature? I can answer this from at least from the clerk's perspective, is that the orders that we are uploading into CMS, they have told me that they're validating those by priority, and the judges are getting priority for those documents first. That's what I'm told. I don't know the lag time, but at least you have something in hand when we hit the button. You get them through your email. You have something in hand. So on a case-by-case basis, if you have an emergency proceeding, please, I implore you to call the clerk's office and let them know that you need those orders validated.
Thank you, Judge. We're also getting a few questions regarding deadlines in guardianship cases. Has anything been extended there?
You know, we have to be as practical as we can. If it needs to be, then at a minimum, please file a petition. We get that all the time. Do a petition for an extension with a proposed order. We're going to look at it. We're going to be cutting everyone as much slack as we possibly can. Keep in mind, we don't control the auditing department, and what they're going to do and how when this is all over, even in between, if they're in any way, shape, or form operational, we can't speak for them. So if you do that petition for an extension saying, you know, here's the issue, we can't get this information now. I'll give you the best example. You have a ward, the ward's in the facility is under lockdown. You're due for your annual plan. You obviously can't get a doctor's report. Doctors are bound to essential services only. So just file that petition saying you can't do it now. You're requesting an extension. You don't even need to come up with a date. That when just put in the order and in the petition that when we resume some sort of normalcy in our operations, that the guardian's going to take care of what the guardian needs to take care of. You know, this isn't a question we candidly anticipated. So I'm hoping the other judges agree with me.
I agree with you, and let's take a step further. They're the clerks, we're the judges.
Agreed.
We're the judges, okay? I mean, we understand. I mean, if they're trying to send out non-compliance, we'll deal with that. In this crisis, I don't suspect they'll do that, so no worries.
Well, actually, please suspect that they will, because they said,
And by the way,
and I'm telling them no worries.
yeah, even though it's not an essential service. For some reason, there's certain people in the clerk's office who I think you're even working remotely who are trying to either justify themselves or think it's essential. It's not.
No worries.
And I've sent a memorandum saying point blank, you can reset them when we resume services.
No, I agree.
And that was my directive to the clerk.
and by the way, that's the perfect ex parte petition and order.
Agreed.
How should we certify that we have the original will and death certificate and other documents on the pleading we're sending, or a separate document with the certification?
You know, we've talked about this, and if you file a petition in normal times, then say that you are petitioning for the admission of a will, and you haven't filed a petition for lost will or anything else, we are going under the assumption that you have signed that in good faith and that you are in possession of the original will. I don't personally want more than your signature on that initial petition saying that you have done that you have it. You don't need to certify that you have it, because you shouldn't be filing a petition to admit an original will if you don't have it.
I don't think I see any other questions. If anybody has a question, they should submit it right now.
Please, we got at least 5 or 10 minutes of our downtime. So if this is the time you got questions, we want to answer them.
So someone's asking about notarization, which, you know, lots of people are struggling with right now. If a document requires notarization, such as a criminal history affidavit, can we submit them without the notary and supplement it later?
You know, there is some statutory change on virtual notarization. I don't know if we can make that work.
It's very difficult.
You
A
know,
lot
if
A
the
lot of
person,
lawyers have tried to sign up, and it's almost impossible for an individual to sign up to become a remote online notary, but there are some companies out there that are doing it.
you know, thinking outside the box, maybe what we can do is go back to the concept that we were talking about when a person testifies, they present documentation. An official document, it could be a passport, it could be a driver's license, something that has a picture and has their name. But again, please, please, for everyone's safety, redact the remainder of the confidential information. And if we get that, I think we're just need to, you know, personally, look the other way. And when it's all said and done, if need be, they need to, you can put a statement on that form, just like you might do in an affidavit, saying that that they are signing this under penalties of perjury.
Yeah, let me chime in. Samantha, I think you're referring to, if I recall, House Bill 408, the Electronic Document Act. You're correct about the notarization. I can't tell you, I can't think of one firm here in Broward that has actually taken that that undertaking to have the electronic notarization. Not only does it require a $25,000 bond, but it also requires them to be the depository of those type of documents too. So I don't think you're going to find many firms. I could be wrong. I don't think you're going to find many. I've not heard of one yet. So it's just going to be a case by case basis. Supplementing later may be something we can look at. Yeah.
Someone's
Hey.
asking about incapacity hearings. Are they being held by telephone as well? And examining committee reports?
Incapacity hearings are not an essential service. And as such, the only incapacity hearings that we are doing, or that the GMs are doing, are those that were already in the pipeline. We, for whatever reason, and this is a sort of a quagmire that we've gotten ourselves into, is the clerk, through their administration, indicated that they were not going to be doing anything with incapacities because it's not an essential service. Yet, when an incapacity petition is being filed, we are getting an order formulating the examining committee and doing the court appointed. Again, it's not an essential service. They're setting hearing dates into April. It's naive to think that we're going to get the examining committee in most situations to complete their reports. It's naive to think that the court appointed is going to be able to do it. And it's even more naive to think that we're going to be able to necessarily have a hearing. But nonetheless, we're entering those orders with the thought process that if the order's in place, at least at a later time, we will be able to recapture and go back to those that are still outstanding. The other thing is the tolling order of the Supreme Court is going to toll the staleness, or lack of staleness, I should say, of any examining committee reports that have been done.
And just to correct myself on the electronic, back to Samantha on the electronics notarization, I cited House Bill 408, but it's in fact House Bill 409, so I was very close. So if you're aware of any firms out there who's doing Electronic Wills Act, can you please forward that to me? I would like to know.
We will. Thank you. Back to the hearings, two things. A couple people have said that Judge Powell has no availability on CMS. I assume that's for a motion or a special set. And could we possibly get each of you to summarize your rules on the hearings, and we can send that out to everybody?
They're pretty uniform, I thought.
I will check with JIS.
Thank you.
Because they're the ones that open up the calendar, and it should be open. There's no reason for it not to be.
Yeah. Just happen to ask it.
I think in summary, for myself, ex parte and motion calendar, if you submit them and they can be done, if they're not opposed, if there's not, if it's not a issue where you need a hearing at motion calendar because there's more than one side, I'm going to try as best as I can, and I have been, to enter those orders without the necessity of a hearing. You're not going to get a phone call from me. You're going to get an order. And if you don't get the order and you put it in the portal, then you're going to get a rejection of the order. And it's going to say what's wrong with it so that you can fix it and resubmit it.
Let me just,
I personally only want to have hearings at motion calendar on those matters where you have different parties involved and they all need to be heard. And again, I'm going to ask, and we have our local rule on this, you need to confer together and if possible, reach a agreed order. I hope that answers that one.
and let me also piggyback on what Judge Greene just said. Guys, I'm sure we don't pay a lot of attention. We don't give a lot of attention to our staff attorneys, Caleb Johnston, Eric Weisberg, is this Weisberg, and we got Lilith Bailey. They're our staff attorneys. I can tell you what Judge Greene and Judge Powell and I have both, what we have all three been doing since we've been on this COVID-19. If you're the ex parte matters, if they come in and they can't be reviewed, depending on how many comes in a given day, there's some lag time. But we're trying to at least split those up where they can be looked at, reviewed. If there's something that are perfunctory, we sign those orders. They are working remotely, and they basically keep our jobs, keep our divisions moving. If it were not for them, I don't see how we can keep up, quite frankly. So I just wanted to make sure, acknowledge our staff attorneys. They're doing a fabulous job. And our JAs, even though they're working remotely, they're doing a fine job in trying to field all your pleadings that are coming through. We got to run the probate division. So for my division, keep doing what you're doing, and we will eventually get to your petitions, your motions, the best that we can. I agree with Judge Greene on those that we can resolve, on those that are resolved, put them in our agreed portal. On the ones that don't require hearings, just keep doing what you're doing, submit them, upload them to our portal, and we'll sign off on them. On the contested ones, that's on a case-by-case basis, but the more time that we have that are on the uncontested matters, we can get to those things that really need to be just signed off on.
All right, with regards to the last question, I think all three of us are doing the same thing. Agreed orders. The agreed order should be on the agreed order portal. Ex parte, you can upload it. Make sure that you upload the supporting documentation showing a reference number. Now on the contested hearings that are set on my calendar, I would like to continue to have that petition or motion together with the proposed order sent to my JA. If you all can't agree, chances are that I'm going to be adding things to that order. So that's the only situation where I want the order sent together with the documents to my JA. So I hope that answers the question. Now, I have a question that was just sent to me.
Before you do that, Mily,
this is it.
Hold on, Mily, hold on. I think
I'm texting back and forth with our probate counsel on this very issue. And here's the problem that we're getting into. And I don't know how we can resolve this. When everyone puts their ex parte orders into the portal, there has to be some way, and we haven't gone through this with our information systems, and I don't know that we can, to differentiate that this is an ex parte request. So what I'm going to suggest to everyone where you have an ex parte is either on the order, and I'm speaking as I'm thinking, either on the order or on your first page of your supporting documents that you download, say on it right there in large letters, ex parte request, because it's the only way that they're going to be able to differentiate and get to see them.
Well, why don't we file the ex parte form and just say, rather than pick a hearing date, just say COVID-19 or something?
Perfect.
Yeah.
Do that.
Sounds good.
That would be great.
No,
Well,
as a
only the next
supporting,
part.
as a supporting, getting back to Judge Greene, your question, when we look at our portal, we see what a judicial order is, and we know where that comes from. Anything that doesn't say judicial order is coming from the bar, and we can see the name of the person that uploaded it. So those should be ex parte. Right?
Okay. Right.
Okay, because I mean, when I look at them, I know it's a judicial order and where it came from.
Listen,
Yeah,
when you do your ex parte, I think Samantha had a phenomenal idea, which is everyone complete your ex parte request, and it should be the first page of your downloaded documents that would go with the order, and that will help us all.
Right. Okay. Let me make two comments for Gillespie division.
Okay.
I'm not going to be too concerned about orders. We're going to get through that. I think that's the least of our worries. Samantha, you asked moments ago about the electronic notarization. We have our probate counsel just sent me an email. He is absolutely correct. There are no electronic notarizations prior to July 1st. That the electronic notarization has been codified in the statute, which doesn't take place until July 1st of 2020. So we couldn't do anything anyway, even if we wanted to do that.
Well,
So
that's for wills and trusts. I think
that's electronic notarizations, though. I think that deals with electronic notaries, though. If you try to do something electronic you get something electronically notarized, I think it applies to that as well. But nevertheless, I think we are back at square one. If we're talking about an affidavit of criminal history or something that we really need to get something through, I think I'll follow what Judge Greene said. We'll just have to do that on a case-by-case basis and maybe look for some supplemental once we get back operational. Does that make sense?
I think we can make that fairly simple. They just sign it under penalties of perjury that says it right in the document before their signature, under penalty of perjury, and they attach an official identification redacted that just shows their name and a picture. You know, we're all working in uncharted times, and we're doing the best we can.
Thank you. One further question. People are asking about fee petitions.
Fee petitions.
Is that like another hearing?
We are, I know you want to answer that first, Judge, because I got a different procedure how I'm doing things. You want to answer?
You know, we're all incredibly sensitive to the needs of attorneys, guardians to keep their offices open and running. And so as much as we possibly can, we're doing them. That is, to me, an exception. That needs to go to my email of my JA, because those have to be reviewed differently. And so that's one exception that I have, that I want those by email with a proposed order. The documents, in other words, the fee petition has to be included. And that way, either we can individually dissect them, make sure that they're appropriate, or alternatively, we can forward those on to our staff attorneys who will do that work for us and then make a proposal, which we can then review.
Judge Greene, I don't think I've agreed with you all year, but I'm going to agree with you wholeheartedly on that process as well.
Boy, and I thought we've been in agreement.
And I think that's what I asked for initially. So
yeah.
We're all
we're in agreement.
Because I want to make sure we continue to make sure that these lawyers can get their fee petitions to us. and we try to keep up with them, because I remind all of us, we do have administrative order. We're trying to keep them within 3 months. So I would like to see them keep coming, and I'll follow your procedure, Judge Green. I think that's the best procedure that we have, and it gets them time to review. Thank you.
Okay, somebody sent me a question and I'm willing to put it out there if you all want me to right now.
Go ahead.
Absolutely.
Are you able to hear me? Okay. It says, can you ask how court appointed should handle incapacity? I have a hearing Thursday. Can't figure this out.
I think the question that you need to do is you need to examine the record. For example, are the 3 examining committee reports already filed? Has the court appointed filed a report? Those are situations that probably predate the closure, and our GMs are trying to hear those remotely. Going forward, that may, I don't know if anyone heard me. Going forward, that may change, but
You cut off.
I said going forward, those may change as we get to a point where the examining committee members were not able to complete reports, or the court appointed did not have access to their client.
And just so you guys are aware, we have, at Judge Greene's direction, and working with the clerk's office, we are basically all online now electronically. So as soon as we get the petition and filed and appointment of the attorney, the court appointment of attorney, they're electronically filing, submitting those to us, and we can sign off on those within 3 minutes when we get them. So there's no downtime with respect to that. I'll say I see Braulio now is back on. Is that a cue?
I guess that's our cue.
If there's more questions, there's more questions.
You know, from our perspective, the 3 of us, we just want to thank everyone for participating, for your interest. We want to thank you for bearing with us. We're all doing the best we can in a very, very difficult time. Thank again the Broward County Bar and Braulio for putting this together. We will, as this evolves further, we will try to put out word through the Broward County Bar of any changes that we can come up with. And of course, feel free to submit the further questions to Samantha or the Broward County Bar, and they'll try to reach out to us. Again, thank you all, and everyone stay safe.
And let me also add, thank you.
Thank you. Stay safe.
Hold on. Let me also thank you. Do one thing for me. Okay, let me just also thank all the participants and you, Judge Greene, for your leadership, and you, Mily, as well. Let me just end by quoting Susan Orman in these difficult times: family first. I want to repeat myself, family first. For those that we call telephonically and you got little ones running around, as long as I can hear you, we get the issues, I can care less. They can run around, they can do what they do, and they're at home. Don't concern yourself much about that. As long as we can hear you and get through the hearing, I'm fine with that. So guys, as we go through this, we're all 3 here for all of you, making sure the probate division runs smoothly as possible. But again, let's not forget family first, and thank you all for participating.
I think I'm just gonna throw in one thing.
Thank you,
I
everyone.
for all the lawyers on here, that we really appreciate everything that 3 of you and your JAs are doing for us. So thank you.
Thank you.